treat minority requests equal with majority requests, that you discourage the National Archives from responding to Ranking Member Feinstein's request, which she tried to craft with you to be identical to the request for records from Justice Kagan. We should not be proceeding until we have the full documents that allow us to review the judge's records.
And Mr. Chairman, last Friday we learned that nearly 102,000 pages of documents from Judge Kavanaugh's work in the White House counsel's office are being withheld from the committee and the public based on a claim of constitutional privilege. Executive privilege has never been invoked to block the release of presidential records to the Senate during a Supreme Court nomination. This includes when Justice Kagan was nominated to the Supreme Court, as well as Justice Roberts. Yesterday, my colleagues and I sent a letter to the White House counsel asking that the president withdraw his claim of privilege over these documents so that they can be made available to this committee and to the American people. We have not yet received a response to that letter, so we should not be proceeding until we have a response and these documents have been available. It is 102,000 documents.
And Mr. Chairman,
my motion to adjourn, Mr. Chairman, to raise this issue of executive privilege and whether it has been properly asserted for reasons that have been outlined well by my colleague, Senator Whitehouse. There is no valid claim here of executive privilege. Even if there were one, it has not been properly asserted. The question is, what is the administration afraid of showing the American people? What is it trying to hide?
And Mr. Chairman, using your own words in the statement you just read, you said, I quote, "We've had more than enough time to review the documents." Sir, we just got a document dump last night of over 40,000 pages. I would venture to say not one senator here has had time to read through those 40,000 pages. And so we are continuing to rush through this process, a process that deserves to be scrutinized. I support Senator Blumenthal's motion to adjourn, and I hope that we could at least have a vote on that motion.
Mr. Chairman, I think you'd be hard-pressed to find a court in the country that would not give a party litigant a continuance when the party on the other side did a 42,000-page document dump after close of business the night before trial.
Mr. Chairman, we waited for more than a year with a vacancy on the Supreme Court under the direction of your leader in the United States Senate, and the Republic survived. I think the treatment was shabby of Merrick Garland and President Obama's nominee. The fact that we cannot take a few days or weeks to have a complete review of Judge Kavanaugh's record is unfair to the American people. It's inconsistent with our responsibility under Article 2, Section 2 of the Constitution to advise and consent on Supreme Court nominees.
Senator Cornyn, you want to speak? Mr. Chairman, thank you. I'll be very brief. I would just say that Senator Whitehouse has suggested that we handle this hearing like a court of law. But I would suggest that if this were a court of law, that virtually every member on the dais on that side would be held in contempt of court. Because this whole process is supposed to be a civil one where people get to ask questions and we get to get answers. And that's the basis upon which we are to exercise our constitutional responsibilities of advice and consent. So I would just suggest we get on with the hearing. If my colleagues...
Mr. Chairman, I could just respond. Mr. Chairman, if I could just respond.
Chairman,
if we could just respond to that.
I would...
Sir,
you can respond, but just a minute. If people wonder why the chair is so patient during this whole process, I have found that it takes longer to argue why you shouldn't do anything than let people argue why they want it. These things are going to be said throughout this hearing. We're going to be in session Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, till we get done this week. So however long people want to take, we're going to not necessarily accommodate all obstruction, but if people got something to say, this chairman's going to let them say it. But it gets pretty boring to hear the same thing all the time. Senator Booker, make it quick, please.
I really appreciate the deference, Mr. Chairman. The question was, why would we want to delay this? And this is not an attempt to delay. This is an attempt to be fully equipped to do our constitutional duty, which everybody, Republicans and Democrats on this committee, take seriously. It is very hard to perform our role of advise and consent when we do not have a thorough vetting of the background of the candidate in areas which the candidate himself has referred to as the most formative part of his legal career, where he himself has talked about how important this period of his life is. We're denied the full vetting. And sir, this is not something that Democrats are asking for. I remind you that you yourself asked for a limited set of documents for when he was in the White House counsel's office. You yourself set that standard. And even on that limited standard, sir, we have not received the documents. And then even the documents, we've received 7% of them. Almost half of those have been labeled committee confidential. They cannot be put before the American people, which further undermine and inhibit our ability to ask questions to thoroughly vet this candidate and advise and consent the President of the United States. So, sir, just on the basic ideals of fairness, the traditions of this body, we should have a thorough understanding of the nominee that's put before us so that we can vet them. To go into this hearing without those documents is an undermining of the constitutional role to which we have all sworn an oath to uphold.
Mr. Chairman, I have great respect for my colleague from Texas.
I would like to respond to Senator Booker, and then Senator Feinstein has asked for the floor.
Mr. Chairman, I asked to respond to my colleague from Texas. Mr. Chairman.
Senator Booker, using a standard set by two members of your political party in the caucus, and I'm going to phrase because I don't have the exact quotes in front of me, but recently Senator Schumer said from the floor, the best judge of whether or not somebody should be on the Supreme Court is decisions that they've made at lower courts. Senator Leahy said something similar to that when Senator Sotomayor was before us, that we know what you have done in a lower court. That's the best basis for knowing whether or not you ought to be on the Supreme Court. So we have 307 cases that this nominee has written decisions on as a basis for that, and we've got 488,000 other pages, and maybe the senators haven't read them, but their staff is fully informed, because last night before 11 o'clock, on the 42,000 pages that have come to our attention, the staff on the Republican side has gone through that.
But, sir, then why didn't you ask for the White House counsel documents? They were not germane to this hearing. Why would you even ask for them?
Senator Feinstein.
For the record, that's a rate of 7,000 pages per hour. That's superhuman.
Yeah.
They're amazing. They're amazing.
Mr. Chairman, if I may, I've been through 9 Supreme Court hearings.
Is this your opening statement?
It's part of it.
Well, why don't you make your opening statement?
Shall I?
Yeah, would you please?
Mr. Chairman, I asked an opportunity to respond to my colleague from Texas because he has directly challenged us with...
I said you're out of order.
Well, Mr. Chairman, I asked in the process of regular order an opportunity to respond to what I believe was a personal attack.
I'd like to have you give Senator Feinstein the courtesy of listening to her opening statement.
Well, I was just going to say some things. And you heard that this is my 9th hearing. And I think we've got to look at this. These are very unique circumstances. Not only is the country deeply divided politically, we also find ourselves with a president who faces his own serious problems. Over a dozen cabinet members and senior aides to President Trump have resigned, been fired, or failed their confirmations under clouds of corruption, scandal, and suspicion. The president's personal lawyer, campaign manager, deputy campaign manager, and several campaign advisors have been entangled by indictments, guilty pleas, and criminal convictions. So it's this backdrop that this nominee comes into when what we're looking at is he within the mainstream of American legal opinion? And will he do the right thing by the Constitution? We are also experiencing the vetting process that has cast aside tradition in favor of speed. When Justice Scalia died, Republicans refused to even meet, even a meeting in their office, with President Obama's nominee, and held the seat open for 1 year. Now, with a Republican in the White House, they've changed their position. The majority rushed into this hearing and is refusing to even look at the nominee's full record. In fact, 93% of the records from Kavanaugh's tenure in the White House as counsel and staff secretary have not been provided to the Senate, and 96% has not been given to the public. We do know what the White House thinks of this nominee. Don McGahn, the White House counsel, spoke to the Federalist Society and made clear Brett Kavanaugh is exactly the kind of nominee the president wanted. In his speech, Mr. McGahn discussed President Trump's 2 lists of potential Supreme Court nominees. One, he said, was filled with mainstream candidates. The other list included candidates that are kind of too hot for prime time, the kind that really would be really hot in the Senate. Probably people who have written a lot. We really get a sense of their views. The kind of people that make people nervous. That's a quote. Now, what I'm saying, this is the backdrop into which we come into this situation. So, yes, there is frustration on this side. We know what happened with the prior nominee, the last one President Obama presented to us. He never even got a meeting. He never got a hearing. He never got a vote. And now the rush to judgment and the inability to really have a civil and positive process ends up being the result. I really regret this, but I think you have to understand the frustration on this side of the aisle. Everyone on this side of the aisle wants to do a good job. They want time to be able to consider what the findings are. And there are tens of thousands of pages of emails and other items which could constitute findings on a whole host of major subjects that this nominee may be faced with. And they're serious. The torture issues, all of the Enron issues that he's been through, all of the kinds of things that we want to ask questions about. So, I mean, understand where we're coming from. It's not to create a disruption. It's not to make this a very bad process. It is to say, majority, give us the time to do our work so that we can have a positive and comprehensive hearing on the man who may well be the deciding vote for many of America's futures.
Mr. Chairman, I renew my motion to adjourn and Senator Harris's motion to postpone. I ask for a second.
Second the motion.
Mr. Chairman, I ask for a vote.
Yeah.
I ask that we
I don't know.
reconvene in
I shouldn't
executive session.
I shouldn't have to explain to you we're having a hearing. It's out of order. We're not in executive session. That'd be the proper forum for entertaining motions.
I ask that we reconvene in executive session.
We won't vote on Senator Blumenthal's suggestion. We won't follow your suggestion.
Well, it's a motion, Mr. Chairman.
To go into executive session. Motions would not be proper at this time.
Mr. Chairman, it's a pending motion before the committee.
Mr. Chairman, if there is no vote on this motion, which has been properly seconded and which could be given a vote in executive session, this process will be tainted and stained forever. I'm asking as a member of this committee, it's my right to do so, that we vote on my motion to adjourn and Senator Harris's motion postponed, and that we do it in executive session, which can be easily and quickly convened right now.
Yeah. The motion is out of order.
Sir,